This module will provide an overview of laws, legal requirements, and the roles and responsibilities of the ARC members. It's important to understand the technical language of special education. Specific definitions can be located in the current IEP guidance document, Kentucky regulations, and in local policies and procedures. The purpose of special education is to ensure that all students eligible for special education services are provided a free, appropriate public education, commonly known as FAPE. FAPE emphasizes special education and related services designed to meet their unique needs and prepare students for further education, employment, and independent living. Special education is also designed to ensure students' and parents' rights are protected and to assess and assure the effectiveness of the individual education program. Each of these federal laws and subsequent state statutes and regulations affect special education. IDEA, or the Individuals with Disabilities Education Act, was reauthorized in 2004. The purpose of this law and its regulations is to make sure that all children and youth with disabilities have available to them a free, appropriate public education, or FAPE. Another purpose of the law is to make sure that the rights of children and youth with disabilities and their parents or guardians are protected. Kentucky has state regulations, known as KARs, or Kentucky Administrative Regulations, that further guide us on the federal and additional state requirements. The Every Student Succeeds Act replaces No Child Left Behind and creates a long-term policy that gives states additional flexibility and provides more state and local control over the accountability process. ESSA provides an opportunity for Kentucky to create a new accountability system that will be used as the basis to better our schools and celebrate their educational progress. The goal is to produce a system that will improve the education and readiness of all Kentucky students and is fair, reliable, valid, and easier to understand than the current system. The Americans with Disabilities Act is an important civil rights law. It protects the rights of persons with disabilities of all ages and makes discrimination against the law. It applies to both public and private programs. It also applies to other important aspects of society, such as public transportation, radio and television, telephones, hotels, libraries, and so on. Section 504 of the Rehabilitation Act, also a civil rights law, deals with the rights of all people with disabilities. This law was enacted to forbid discrimination on the basis of disabilities in any program or activity that receives federal funds. This law makes sure people with disabilities have rights in their community. More specifically for children and youth in school, it means that school districts must provide students with disabilities the same opportunity to succeed in school as they provide to students without disabilities. Schools, including colleges, universities, and vocational schools, must be equipped so that people with disabilities can get into and out of buildings and move around safely. The Family Education Rights and Privacy Act protects the confidentiality of student records. This law makes sure that staff members are trained in confidentiality and that records are protected during creation, maintenance, and destruction phases. This section will provide you with an overview of laws impacting special education services. As you know, federal law sets the requirements for special education services. From there, state law can be more restrictive, but not less, and local procedures can be even more restrictive than state. Kentucky has some of the most restrictive special education laws in the nation. Most special education paperwork is required because of the legal obligation set forth in these laws, regulations, and policies. Documentation is needed to prove that these obligations have been met. Documentation proves that we've done our job. The most recent update for IDEA was in 2004. Kentucky administrative regulations related to exceptional children were most recently updated in 2008. Local district policies and procedures are updated annually. The record review document, which is also updated annually, is used for monitoring local school districts. A link to the most recent record review document is included at the bottom of this slide. You may have heard it said, if it's not written down, it didn't happen. This can be seen in two ways. It must not have happened if it wasn't written down, so it may seem like you have a release of liability. However, if it wasn't written down, then what you did, good or not good, is not documented and cannot be supported in court. So be sure to document everything you do, regardless of your relationship with a parent, and even if that parent is a good friend. Before 1975, it was uncommon in the United States to offer education and rehabilitative services in public schools. In fact, many states had laws explicitly prohibiting the enrollment of children with disabilities, particularly children identified at the time as being emotionally disturbed or mentally retarded. Public Law 94142, known as the Education for All Handicapped Children Act, became the law of the nation in 1975. This landmark legislation required all states receiving its associated funding to provide skills-based individual education plans for students with disabilities. This law was reauthorized and expanded as the Individuals with Disabilities Education Act, or IDEA, in 1990. IDEA was reauthorized again in 1997 and 2004. The 1997 reauthorization mandated students with disabilities have access to the general curriculum, and that IEPs be aligned with curriculum standards. It also expanded the definition of developmental delay to include school-age children aged 5 till 9. Federal regulations for the 2004 reauthorization were released in August of 2006. The purpose of this law and its regulations is to make sure that all children and youth with disabilities have available to them a free, appropriate public education. Let's take a closer look at what a free and appropriate publication means. The free, appropriate public education is guaranteed both under the Rehabilitation Act of 1974 and the Individuals with Disabilities Education Act. Under IDEA, FAPE is defined as an educational program that is individualized to a specific child, designed to meet that child's unique needs, provides access to the general curriculum, and meets the grade level standards established by the state and from which the child receives educational benefit. Free means the free public education of educational services must be provided at public expense, under public supervision and direction, and without charge to parents, except for fees that are charged for all students. Appropriate education will include education services designed to meet the individual education needs of students with disabilities as adequately as the needs of non-disabled students are met. The education of students with a disability with non-disabled students to the maximum extent appropriate to the needs of the student with a disability. Also assured under FAPE are contingencies for evaluation. Evaluation and placement procedures established to guard against misclassification or inappropriate placements of students, and periodic reevaluation of students who have been provided special education or related services. It also includes access to the general curriculum to meet the challenging expectations established for all children. In Kentucky, districts will approve a free and appropriate education to all children with disabilities who are ages 3 to 21, reside within the district boundaries, and have not yet received a high school diploma, including students with disabilities that have been suspended or expelled more than 10 days in a school year. Child find. All districts must have child find policies and procedures in place that includes activities to locate, identify, and evaluate a child ages 3 to 21 who reside in a home, facility, or residence within the LEA's geographical boundaries, including children with disabilities who attend private schools located within the LEA boundaries, highly mobile children, such as migrant children, children who are homeless, wards of the state, or in state custody. Advancing grade to grade due to a passing grade but who may still have a disability, students who are either in or out of school and who may need special education and related services. The Admissions and Release Committee, ARC. No decision regarding a potential or identified student with a disability will be made by one individual. The law requires that decisions be made by a committee. These committees are commonly referred to as ARC or ARC meetings or IEP teams. This committee should always provide for parental participation. There are 4 basic types of ARCs. ARC meetings can be held for referral or initial evaluations, to discuss evaluations and eligibility for special education services, annual reviews, and for other reasons, such as to determine manifestations of disabilities related to discipline, the transfer of a student with a disability from one state or school to another, to review the lack of progress or add special transportation. Essentially anything that may lead to a change in the child's individual education programming or impact their least restrictive environment. The evaluation data used for all decisions should be discussed and documented on the notice or conference summary and kept as part of the student's due process folder. All decisions are documented in writing, and if the student who is found eligible for special education services, the documentation is kept as part of the student's due process folder. If the child is found not to be eligible for special education services, the documentation is kept in the student's regular, permanent, or cumulative folder. Progress data is used to make decisions and must be present at the Admissions and Release Committee meetings, or the meeting should be canceled. Progress monitoring for initial evaluations is largely dependent upon the initial evaluation's RTI data. Reevaluation and annual reviews will use a combination of progress monitoring maintained by special education support staff and other assessment information from the general education environment. It's critical that this data be analyzed and used to determine educational programming. Without proper representation, decisions may not be valid if the ARC is not properly established. When evaluation results are being discussed, someone who can interpret the instructional implications of those results must be present. The required members of an ARC include the ARC chairperson or local education agency representative, commonly known as the LEA rep. Also required are a regular education teacher and special education teacher. Other members that may constitute an ARC include the child's parents. The law is very clear. Parents must be afforded the opportunity to attend and participate by providing input at all points in the process. Beginning at age 14 and in the 8th grade, students must be invited to an ARC meeting. Many of the requirements for providing parent inputs and opportunities to participate in the processes are outlined in the procedural safeguard sections of both the Kentucky Administrative Regulations and local district policies and procedures. All parties necessary for the meeting to occur need to be included on the notification of conference, but you only list their roles, not specific names. For example, LEA rep or designee, general education teacher, special education teacher, and so on. Other members who may be included in an admissions and release committee are a related service provider, such as speech-language pathologist, occupational therapists, and physical therapists. If you're inviting outside agencies, you must receive prior consent of the parent or guardian. Any other person requested by a member of the ARC to assist in decision-making for the student may be invited. Parents have the right to invite whomever they choose, such as an advocate or outside therapist. ARC membership. It's important to document ARC membership by completing the notice and providing signatures at the end of the meeting. On the signature page of the conference summary, the signature should match the title invited on the notice of the ARC meeting. It requires signatures, not typed names. Only those in attendance should sign the signature page. Signatures should not be gathered after the fact. Make sure you identify the individuals that need to attend the meeting prior to the invitation and invite only those necessary to conduct the appropriate meeting. Roles and responsibilities of the ARC. The ARC chair is the local education agency representative, or LEA representative. The LEA representative must be someone who is knowledgeable about general curriculum, qualified to provide or supervise the provision of specially designed instruction, and knowledgeable of the resources needed to implement the individual education program. Designees must meet requirements of the ARC chair and be approved per district policies and procedures. Individuals other than principals may be approved as ARC chairs, but it's important to check your district procedures to see steps taken for board approval. The ARC chair cannot be the teacher of the child. Procedural safeguards notice, or parent rights. Parent rights are given to parents one time per year and upon several conditions. Upon initial referral or parent request for an evaluation, upon the receipt of a first state written complaint, upon the receipt of the first filing of a due process hearing in a school year, in accordance with discipline procedures in which the decision is made to remove a student, which constitutes a change in placement because of the violation of a code of student conduct, and upon parent request. Determination of educational representative. Each district should have a process in place for determining the educational representative. Details for this can be found in Kentucky Administrative Regulations coded upon this slide, 707 KAR 1340 Section 6. Documentation must be filed in the due process folder. A biological or adoptive parent of a child may be the child's educational representative. Additionally, a guardian, generally authorized to act as the child's parent, or authorized to make educational decisions for the child, but not the state if the child is a ward of the state. An educational representative may be a person acting in the place of a biological or adoptive parent, or a person legally responsible for the child's welfare. It may also include a foster parent or surrogate parent. A school district must keep a record of reasonable efforts it makes to discover the whereabouts of a parent, such as detailed phone records, copies of correspondence, or detailed records of home and work visits. The Notice of Admissions and Release Committee meeting. The notice should be addressed to the parent, guardian, emancipated youth. Be sure to check for the correct name of the parent or parents. The law requires 7 calendar days notice. Except for meetings concerning a disciplinary change in placement or a safety issue, an LEA shall provide written notice to the parents of a child with a disability at least 7 days before a meeting. It's important to note a phone call alone does not constitute the required formal written invitation. An LEA shall provide written notice to the parents of a child with a disability at least 24 hours before a meeting concerning a safety issue or a change in placement due to a violation of a code of student conduct. The notice should also include the purpose of the meeting. Transition should be checked for students beginning at age 14 or older or in the 8th grade, whichever comes first. The notice must include a mutually agreed upon time and place. You must have documentation of multiple attempts to contact the parent or parents or the emancipated student. This may include documentation of a phone call written on the notice of ARC committee meetings, documentation on the parent contact sheet, home visits, or other correspondence with the parent. 2 notices must be given before the meeting can proceed without parents in attendance. You must document this. Roles invited to participate. Include role, not specific names. For transition, 8th grade or children age 14 and over, parent confirmation of the meeting or request of special needs. Alternate means of meeting. A conference call with a fully convened ARC. We use this only when the ARC chairperson is unable to convince the parent to attend. Participants must introduce themselves and explain their roles. Alternative meeting place may be offered as an option, for example, a home, a school closer to the parent's home or workplace. You may need to even have an interpreter. It's important to note that all invited parties must be included on the notice of invitation. If someone is in attendance that is not on the notice, they must receive permission from the parent in order for the meeting to continue. Procedural safeguards can be explained prior to or during the ARC. The ARC's chair responsibility is to make sure that the procedural safeguards are reviewed and understood. Take them to the parent to the signature page on the conference summary and show what that means. Procedural safeguards were most recently updated in Kentucky in 2009. It's important to note that the procedural safeguards notice shall include a full explanation of all the procedural safeguards available under Kentucky administrative regulations. Additional information that may be sent to parents prior to the meeting to discuss a referral is a copy of the procedural safeguards, including parent rights. According to regulations, parents receive this information upon initial referral or upon request for an evaluation. Although you may send a copy prior to the meeting, a full explanation is also required. So the information, even if sent prior to the meeting, will be reviewed and discussed as needed during the referral meeting. Districts may place a current copy of the procedural safeguards notice on its internet website if such website exists. Parents may elect to receive notices by electronic mail if the district makes such options available. The 7 deadly sins is a common expression used to understand common due process issues schools may face. The reasons districts often enter into due process can be tracked here. Schools enter due process issues for 1. Committing procedural violations, 2. Denying service based on cost, 3. Refusing to consider something new or different, 4. Giving in to parent demands without cause, 5. Acting on principle rather than reason, 6. Failing to assume the burden of proof, and 7. Failing to secure services in a timely manner. The foundation of special education is decision-making focused on documentation and the analysis of data. It's important that the ARC analyze data. It cannot just list scores and data in a conference summary notes. There must be an analysis of the data and a discussion on what that data means within the conference summary notes. Document your analysis and its implication for the students in the conference summary. This slide contains additional resources that may help ARC chairpersons. The website includes eligibility policy letters and a webinar that explains the policy letters, the guidance document for individual education programming, and the lesson plan development handbook. The Kentucky System of Interventions, or KSI, RTI documentation, SLD eligibility guidance, collaborative teaching practices Q&As, restraint and seclusion Q&As, the compliance record review document. This concludes Module 1.